everyone. This is Caroline Griffin. I am the Events and Operations Manager for Riot. On behalf of Riot, I would like to thank you for joining us today. And I would like to introduce Eli Sheets with IdeaBlock. Thank you for joining us today, Eli. Just a couple of quick reminders. This event session will be recorded and posted to Riot's YouTube channel. Please, if you have any questions, please put those in the Q&A box and we will take all questions at the end of the presentation. And then if you need help connecting to Eli, please leave your email address in the Q&A box and I will help make a connection for you. So without further ado, we will go ahead and get started. Thank you for being here today.
Well, thank you, Caroline, and thank you to Riot and Tom and all the folks at the organization, and thank you all for coming. So today I would like to present, as the title of the presentation kind of indicates, the case for blockchain for protecting intellectual property in your IoT data and your IoT inventions. I know a lot of you, obviously, by nature of the company or the nature of the group, are interested in the Internet of Things and the associated ecosystem. And obviously, there are a lot of issues around IP in that world right now. So, I thought this would be a relevant presentation to introduce our company and our products to you all as an alternative to traditional intellectual property protection, and a way for you to learn a little bit more about IP and blockchain in the process. So just quickly a little bit about me. So I'm an engineer and programmer, went to studied computer science and electrical engineering at MIT, University of Wisconsin-Madison. After getting my degrees, went to work for the USPTO as a patent examiner. Stayed there for a couple of years, then went to law school and clerked for a couple of federal judges, doing a lot of intellectual property work, and then worked at a few firms for about a decade, and came down here to Raleigh-Durham after we had a couple kids. I've got 4 boys. So quarantine's been interesting, to say the least, with homeschooling and everything. So we've got a lot going on. But moved down here to be closer to family, and worked for a firm here, and hadn't kind of thought of the idea for what IdeaBlock is after a little bit of practice down here, doing some patent work down in at a firm here in Raleigh, and decided to make the jump to start a company around it. And that's what I'm going to tell you about now. So for those of you who need a little quick refresher on traditional intellectual property, or the forms that the protection can take, in the United States and really in the world, there are 4 big buckets. So you have patents, trade secrets, copyrights, and trademarks. Patents are issued by the government. In the United States, the United States Patent and Trademark Office. In other countries, similar offices that give temporary monopoly for inventions that satisfy a certain set of criteria for inventiveness and novelty and associated concepts. Trade secrets are a group of rights that attach to folks who, instead of choosing to make their ideas public during the patent application process, they decide to keep them silent, keep them secret, and kind of build up an infrastructure of protection around those secrets to make sure that the knowledge of those secrets is limited. And United States courts give protection over those trade secrets for any malicious stealing of those trade secrets and whatnot. Copyrights are, you typically see those associated with works of art, music, and in the last couple of decades also for computer code. And they're not necessarily the most robust protection, because the breadth of their protection is pretty isolated to the work itself. So for code, for example, it's not necessarily protecting the underlying functionality of that computer code, but it protects, for example, operating systems used to come on CDs, right? The exact kind of installation operating system kernel that's on there. It would protect those exactly, but obviously also easy to design around. Trademarks, those are a little bit of a different animal. They are associated with traditionally with giving the public a representation or source of certain goods to ensure that the public has some information about where these goods are coming from, to give them confidence in a set of goods that are marked with this trademark. Common, any type of trademark that associated with a good that in the United States, McDonald's, again, this is also associated with trade secrets, but Coca-Cola, the source of these goods is trusted, has been around for forever, and so these brands become very valuable around that type of IP. So with that in mind, moving on to some of the issues with traditional IP especially over the last few decades. The first one being traditional IP is generally expensive, and that's oftentimes an understatement. So the average cost of, as it says here on the slide, of obtaining a United States patent through its lifetime is $60,000. And for a startup looking forward, $60,000 at the front end for a right that you might not get even obtain from the United States government, let alone through its enforcement and whatnot, and you're not even going to see that benefit until it goes to this application process. $60,000 on the front end is a hefty price tag to protect something right away, right? To write off the budget. It's not only true of startups, but also for large corporations. I mean, even your most well-backed and financially sound companies that have large intellectual property portfolios, like your IBMs, Qualcomms. They have to decide what intellectual property they're going to protect, because they can't protect everything at these price tags. So it's a problem it's a limiting factor for not only for startups, but all the way up through growth companies, all the way up through enterprise, the cost of the patent system. And the same is true of other IP systems like trademark systems and copyright systems as well. It's an expensive undertaking, especially given the cost of legal representation and other folks consultants that'll help you through the process, right? So again, the average cost of obtaining an international patent, you can see, is double that plus a little bit more. And average cost of a patent lawsuit, whether you're bringing a patent that you've already obtained, or you receive a cease and desist letter and you're dragged into court, the average cost for either party being $4.5 million. And that obviously speaks for itself in terms of its impact on a company's budget, regardless of its size. So the underlying principle on that, the string that runs through all of these different types of intellectual property, the first in time will win if you can prove it. Okay, so for patents, in 2012, the United States moved from a first to invent paradigm, where the first person who could prove that they had a certain idea at a certain time would beat someone who could prove that they had an idea at a later time, in terms of who actually gets this patent right. Okay, in 2012, the United States moved to what is commonly been referred to as a first to file system, where the first entity to file a patent application with the United States Patent Office would win in time, theoretically. Now, that's true on one level, but if there was prior art existed, prior art being publicly available information that is the same thing as this whatever invention the application that's being filed for exists in the public, that prior art can be used to essentially block that patent from being issued, right? So if I'm a company that maybe can't afford a patent, but I publish a paper and get it published in any magazine or scientific journal that's publicly available, and then subsequently one of my competitors goes in and gets a patent on or file a patent on it, our publication is able to block them from obtaining that patent, right? So that's why, for me, it is first to file on a broader sense, but for me, it's a first to publish, right? So it's whether that's on your own accord or I guess first to file or publish, right? For copyrights, the first to write down. For trademarks, the first to use in commerce and build up a knowledge in the public as to a source of a good. And for trade secrets, we'll talk a little bit about this, but the first company to use a trade secret and hold it as such will actually beat others who subsequently file for patent protection over that idea that this other company has held in secret as a trade secret. So we'll get into that a little bit more in a few minutes. So when it comes to this concept of time and intellectual property, for decades, IP law didn't really have a reliable, provable way to prove time. Now it's, for those of you who worked in tech companies for a while or in intellectual property in some capacity, you'll probably recognize the keeping a lab notebook and dating lab notebooks and whatnot for invention and R&D departments that want to keep track of when stuff was made for this purpose, because they want to know kind of how far back can they prove that they had this invention, right? And that was for most use cases that people would do stuff like that, or companies would do stuff like that, or set up these systems to have to lay out the timeline for inventiveness. That was mostly under the old paradigm of first to invent, because it made a big deal to be able to show when you invented something, right? But a lot of times it's difficult for companies, especially those that are running large operations. It's often difficult to prove that someone's dated lab notebook happened on the date that it was dated, right? In terms of a trial, but also difficult to keep track of this stuff and prove, right? A jury or a judge is going to have to believe you that you had a rubber stamped on a piece of paper, or that a memo internally was on the date that it said. So you've got hand-dated documents, computer systems inside of a private company that aren't auditable by the public, provable in any way that way. Date timestamps on documents like the old ones that you see at the library, right? It's, a lot of these instruments have tried to be used by private enterprises to prove time. And email dates, but no, those are a little better, but at the same time they're still usually kept by the companies themselves. So it's judges and juries often kind of look at those like fox guard the henhouse situation, right? So for each of these, there are flaws, right? So how does IdeaBlock help this problem? In both of these problems, right? The cost problem and the kind of the evidentiary problem of proving when someone had something. So what IdeaBlock does is it leverages blockchain technology, and specifically Bitcoin and Litecoin blockchains, not for the value of actually exchanging value as most people think about those blockchains, but we instead use those blockchains to embed data into this blockchain that will be verified by the thousands of nodes spread out across the world to show when did this invention exist? How do we use it to timestamp stuff, right? We use the existing infrastructure of those blockchains to show when at a specific time these ideas existed, regardless of the type of IP. So IdeaBlock saves money as well. So as we talked about a few slides ago, traditional IP is very expensive, and knowing which ideas you want to protect with a full suite of patents, of a full trademark apparatus or a full trade secret apparatus now, before the market kind of responds to the product and you're able to fully develop it, it's kind of a chicken or the egg scenario for companies. So instead of having to choose, right, and use a crystal ball to figure out which of these ideas that are being produced inside of a company are patent worthy, which ones are we going to choose to invest our budget in. We kind of provide this broad-based defensive protection using our technology to both show what time it was, timestamp each idea as it happens, but also give the companies a way to show when exactly in time this happened. Because instead of having to choose and look into the future, pay the lawyers and get them off the golf course, and 3 months later is when the actual filing will happen, you can timestamp it today, right? And you don't even have to pay the lawyer. You can choose to. We don't block your opportunity to get a patent on anything in the United States, but we provide that first touch time stamping that's irrefutable and lasts forever. So, and again, I've said this a couple times, but IdeaBlock defends against all forms of third-party IP. So, it's not, we can't give any of our clients or our users an actual patent, for example, staying in the patent context. Only a government can do that, right? But what we can do is we can defend you against someone else in your marketplace getting that IP protection, that patent protection, maybe they invest the money into that form of intellectual property and actually are issued that, right? So you can imagine if that happens, if you have a third party, one of your competitors in the marketplace down the line has actually gained patent protection on something that you added to IdeaBlock before they filed for their patent, and then they come around and try to sue you for that later on in time, you're able to invalidate that patent using IdeaBlock, right? So that's kind of the main core use case in the patent sense for IdeaBlock. We also have other use cases that we'll talk about in a minute for other forms of intellectual property, but we are able to prove irrefutably without having to rely on someone's date timestamp in their lab notebook, or something in your secretary dating something on a note on an envelope or anything that screams like the 90s and 80s forms of keeping track of an invention. You don't have to rely on that anymore. You don't have to sit there and prove that these things are true, right? These things that were all internal to your company. We're using a system, right, that's international, irrefutable, and is around forever, right? And is constantly being validated, which is the Bitcoin and Litecoin blockchains. So one of the principles here, and I know that I'd be talking to a bit of a more tech-savvy audience here, is what we leverage to actually put your idea and timestamp it in these blockchains is the idea of hashing, right? So what a hash is essentially, it's an algorithm, and there are many different kinds, but what we use is called SHA-256. It's the same hash algorithm that's at the core of certain blockchains like Bitcoin and Litecoin. What we do is we take your idea, right, or you tell us what your idea is in terms of a file. So you can describe whatever your idea is in files that you're already using, like coders might use JavaScript and HTML, CSS, C++, Java, whatever your language of choice is, and simply upload those files that describe and contain this invention. It could be a PDF. It could be a video of you in your living room, explaining what your idea is. It could be you taking a picture of a napkin at the dinner table, and that you've just scrolled out this idea on, and you simply upload those via our web app, right? And it's just as easy as essentially using like a Facebook or something else for uploading pictures, but instead you're uploading actual proof of your idea. What we do is we take those files, or one or more files, and any additional kind of metadata, like a description of what that is in text form. You give it a title, you add tags, and other things that allow it to be indexed easier for you. But what we do is we wrap that up into an archive file, a zip file. We take the output of that hash algorithm. So we put that zip file or archive file into the hash algorithm, and everything that goes into a hash algorithm, any input data, will have an output data, right? That ends up being 64 character string, just like this. It looks like gobbledygook, right? It has no, you can't read that and figure out what the input files or idea was, but you can't come back the other way from that 64 character string and see what the idea was, right? So how we leverage that is 15 years later, 20 years later, 100 years later, if you put that same group of files into that hash algorithm, you're going to get the same exact hash on the other end. So in this case, the long number that starts, alphanumeric string that starts with 7444 right there. And so if at that time we still have that file that served as the input now and get the same output later, we know that we had that file or that idea, in this case, or that intellectual property at this time. And so we take this hash and we place that into the blockchains, right? So it allows us to take large amounts of data, like a video, and essentially compress that down into 64 bytes, and we place it right into the blockchain, both the blockchains, which timestamps those for us, and we return it and store that for you for forever. And from then on, you'll be able to prove this exists at this time. Okay, so that's the general idea. There's obviously a lot going on under the hood. We can talk about that more if anyone has any more questions, but this is kind of the magic sauce under the hood. So for patent defense, and this is specific use case for patents, right? We can help with that. So there are 3 steps, really, general steps. So first is a user will get an account, they log in and upload a new idea, like I just spoke about, and describe it in one or more files. And for the second step, you essentially wait for us. IdeaBlock's backend will take that user data and the idea, and we tether it to multiple public blockchains that exist now and will exist forever and are verifiable and cannot be changed, right? So this is mathematically provable that what goes in now you cannot change, right? So that's one of the kind of the core principles of these blockchains. And then 3, for the patent defense situation, as I mentioned before, if someone publishes something before someone else goes and tries to file a patent application on that, that prior publication can be used to invalidate that patent, right? So, like the scenario that I mentioned before, where 10 years down the line, one of your market competitors comes back with a cease and desist letter and says, "Hey, we have a patent on this, and you've been in the market, you need to stop." You can print out our verification certificate and say, "Hey, no, actually, we uploaded this; it's timestamped. And in addition to timestamping it, IdeaBlock also publishes ideas that the user chooses to make public. So, for ideas that the user would likely see some patent defense opportunity, all they have to do is upload it to IdeaBlock as a public idea rather than a private idea. And we take care of publishing that on our publicly available searchable database. And we can prove that every single day after you uploaded that it was available to the public, right? So we're serving that patent defense function that way. And that saves our user from that huge bill, that $4.5 million bill later on, for having to go in and come up with that money to defend themselves in an infringement suit, right? So it's in that way, a lot of folks like to tell me it looks a lot like an insurance product. Well, in a lot of ways it is in this use case. So, and then secondly, I talked a little bit about trade secret defense. So, and I know that there are probably some coders in here and people that are in industries that rely heavily on software. So just a quick little background on that. So, as many probably know, that software is a bit of in a gray area in terms of protection, right? It's where there are a lot of different theories and opinions on this matter. But at the end of the day, the way the law sits right now, it's very difficult to get a patent on a purely software invention. As I mentioned before, copyrights, the protection along with that form of intellectual property isn't as robust, isn't as broad as a patent would be. But if you can't get a patent, a lot of people, over the last couple of decades have tried to copyright their code. And, it's the best, one of the better options for that given the circumstances. But now we're seeing, especially after some new litigation at the tail end of the Obama administration was passed, trade secrets have become a way for folks to try to use keeping code obfuscated in different ways in order to hold them as trade secrets. And this is really coming in vogue right now. But there's really never been a way to prove later on to a court that you had a trade secret at a certain time, because divulging it to a third party at that time would essentially be nuking your trade secret because it's no longer a secret, right? So there's this conundrum. And to set this up legally, this is the scenario that this comes up in. So you can imagine a company, let's say Acme company, decides they've got this invention on a cool idea, this cool new widget, and initially they think about what should we patent this or keep it as a trade secret, and ultimately they decide to keep it as a trade secret. Well, if a year later one of their competitors, maybe this is Beta company, comes up with this independently, the same idea, and instead of keeping it as a trade secret, they decide to file for patent on it, patent protection, and eventually they're granted a patent on it. Well, Beta, holding a patent, sees that Alpha is using, kind of reverse engineers or figures out that this is what Alpha's or Acme is using in their in the marketplace on their product, and they sue Acme for patent infringement, right? Well, what do we do in that scenario? Because we have a company that's been holding a valid trade secret on this idea before Beta went and filed a patent application on it. So Beta didn't do anything wrong necessarily. They were first to file an application, a patent application on it. All they're doing is enforcing it against Acme. But Acme didn't really do anything wrong either, because they've been holding a valid trade secret for longer than Beta had the idea. So what the law does in this situation is gives Acme a way out in the form of prior use rights. So what the burden it puts on Acme is that they need to be able to prove with clear and convincing evidence in a court of law that they had and used this idea, this trade secret, before the Beta patent was filed, right? And like I mentioned before, it's very difficult for companies to find mechanisms to do so other than hand dating things, taking pictures and keeping them in secret, in storage secretly inside of the company, and limiting access to those files or forms of proof. Well, given that it's so secretive, it's also limits the viability as evidence, right? As clear and convincing evidence, because no third parties are able to see it, right? It's no one's able to come and testify that you indeed had these documents at this time and had this idea, right? So what IdeaBlock does in one aspect that's available to our users is it provides that clear and convincing evidence, and the way we do that is instead of publicly publishing the files that describe this trade secret on our site like we would do in the patent context and making this public, we instead keep that secret, right? And because it's kept secret, right, and you as the user only has access, is the only person that has access, to the company that has access to these files and this proof, that's timestamped and provably timestamped. When you, as a trade secret holder, eventually get a cease and desist letter from the Beta company that says that they have a patent on this thing, you're now able to prove, with better than clear and convincing evidence, that you had this and kept this idea as a trade secret, and therefore will be able to avoid suit, right? So we've come up with a way that utilizes existing technology, new technology, in the form of blockchain to provide that defensive legal protection for trade secret holders, right? And because there's so many more trade secret holders now, it's really become a tool that a lot of people look at us as something that they value just as much as they do the kind of the patent defense stuff inside of our suite. So I thought if this would work, that we could try to do a demo here if I can figure out how to change my presentation. So what I'd like to do here is try to change my here. Change it to my Chrome here, and hopefully, yeah. So, let's see here. This to not share my keynote for a second. Okay, so this is essentially our. Right now, I guess give some background on where we are in our development. So, IdeaBlock is about 18 months old. Since then, I built an alpha, brought some people on, and also we released our beta product with some partners that are helping us kind of test it in October/November of last year. So this is, and since then we've been building our next enterprise version, which is kind of is going to be our first release outside of beta in the next month. But I thought, just to show you all kind of what this process looks like if I am a user, how do I actually use the IdeaBlock platform to actually protect an idea. So when I set up an account for Riot here just for the demo purposes, but this is kind of a blank slate for a user, and all you have to do to upload an idea, it's pretty, I think, pretty simple. But you click add a new idea, right? And for here, I actually thought we could upload kind of an IoT application. So IoT platform. This is the idea name that anyone would put in, and let's say that let's make this a public idea. So we're let's say for patent defense, and then an idea description. Just took that off. You'll see the file, but you're able to add a description there, right? And then for this, these are two files. The first one being, this is a public patent publication of someone's IoT-related invention, and then a figure from that invention. So I've got a figure that I've made, and I've got a description of the invention that I want to protect using IdeaBlock. So I add those files, okay? And then, since this is my first idea under this account for Riot account here, you don't see any parent ideas, but eventually we're able to, as a user, you're able to kind of add families of ideas by adding parents, right, or identifying parent ideas. So in the past, for example, in the patent context, if you'd filed a patent application on Monday, and then on Wednesday you thought, oh shoot, I should have added this alternative or this extra feature, you're going to have to file a new patent application to get that protected, right? So what we do is we allow people to kind of like Git, for those who are familiar with kind of code management tools and that kind of software that does that. We're trying to replicate that, but in the idea form, right? We'll be able to kind of add different kind of a description of the way that features were added to a larger product, right? So you could add parent ideas there in that slide. And then a thumbnail, which will show up on your user page, you could choose. I'll just add the figure again to that. So you can add tags. So for here, you might do IoT and add anything you'd like to allow you to access your files or search for your files more easily. And then let's see here. Then we finish and submit. Let's see if it'll go through here. And there we have this idea description. Here we have the figure, here our title, and you can see here. There's the figure again, and then here's this is the patent application that describes the invention. So this would be something that you've made on your Word document or something like that that describes an invention, like an invention disclosure at a company, right? And what it's doing in the back end right now is it's establishing the Bitcoin and Litecoin. This is Bitcoin and Litecoin, and these hashes that it just generated, right, show where on the Bitcoin and Litecoin blockchains that your idea hash is now embedded. So now that these files, which describe our idea, this IoT invention, this IoT platform, are now, as of right now, on the Bitcoin and Litecoin blockchains embedded as hashes. So, and you can see here, this actually links to a third-party blockchain explorer, which will show that this is this particular idea was uploaded a minute ago, and that's for the Bitcoin hash, and for the Litecoin hash, again, a minute ago. So we have, two different blockchains, unrelated, that are saying the same thing, right? So now we've had for these there for this idea, this is it isn't confirmed as of yet, but you have two different blockchains, unrelated, that are saying the same truth and will be provable forever, right? So you don't have to worry about judge, jury saying, hey, is that really your timestamp on that lab notebook? Is this your secretary? Did your secretary really do it? We've taken it completely out of that evidentiary realm, and now we've moved it to essentially humans of the old world versus now we're provably doing this with math, right? So in addition, like we said before, the advantages in terms of price are night and day, right? It's orders of magnitude more economical to use IdeaBlock versus those traditional forms of intellectual property to protect inventions. So yeah, I just wanted to run you through that really quickly, just to show you kind of what the platform actually looks like and stay out of the clouds in terms of describing the idea. So hopefully that makes sense. Switch back over to my presentation and see what we have for questions.
Thank you, Eli. We have a number of questions, so I'll just go in order. So you're encoding their ideas into blockchains that can be validated, and then you publish them? Question.
Yep. If the user chooses to. Yeah. Let me see I think there was a list. There's a list, right, of questions too.
Yeah, I can read them out to you, Eli.
Okay, go ahead. Sorry, yeah. Going if I interrupted you.
No worries. What legal entities respect a blockchain from even a well-known coin as proof of contract? We've been told that blockchain we respected by the blockchain's users without the need for legal respect from an authority. So isn't the reverse that legal authority wouldn't trust/respect the blockchain be reciprocated?
Okay, so I think the question is generally kind of directed toward, what authority says that this, this evidence would be any better than anything else, right? We don't have necessarily a precedent on, IdeaBlock's platform being validated by a federal court, and we won't. I mean, for a few years, it has to be someone, at least in the patent context, someone would have to use IdeaBlock and then get sued by a patent that hasn't issued yet on that, and take it to court and get a ruling on it. But taking it outside of kind of the precedent question inside of the judicial branch, we're seeing legislation in 5 states already over the last year that's taken blockchain, and instead of waiting for courts to precedentially make blockchain a provable or trusted form of evidence, the legislatures of states, and there are also bills pending in different states. We're actually working on that in North Carolina right now as well with some folks. But taking that the technology and really taking it sort of out of the judge's hands in a way, and saying, okay, if this is embedded inside of a blockchain, there's some stipulations on that, but Bitcoin is included in all of them. If there's information that's in these blockchains, this is something that's going to be admissible, and this is going to be something that is to be introducible, right, and believed, right? So the one point I'd make on that is, I kind of believe that before a precedent kind kind of system evolves, which can take in the law is usually about 10 years behind technology. Okay, I don't think we're even going to get there. I think the legislatures are going to take care of this, and we already see that happening, right? So that's the first point. The second point is, you've got different kinds of technology. And technology is not new to the law either, right? So you've got situations where tech has been introduced into the legal capacity. For example, the best example that I can give, I think that would hit home with most is DNA evidence. So outside of the problems and Innocence Project problems that we've seen over the last decade or so, over the last quarter century since that technology has been brought to bear in the criminal context. I mean, we're taking people's liberty and life, in some context, going back away from people based on DNA evidence, right? And DNA evidence is very exact, compared to some of these other forms of evidence that existed before it, like eyewitness testimony and whatnot. But it's also a technology that is about 20 orders of magnitude less precise than just one of these blockchains, and we have two of them. So, 20 orders of magnitude is a huge deal, right? And the chances of Bitcoin or Litecoin, either of them being wrong on this, on any of this provable stuff, is as small as one person winning Mega Millions and Powerball 23 drawing straight. Okay, so that's pretty small, right? And it's difficult to describe such large numbers or such small chances. But in my view, that kind of math will be recognized not only in 5 states but in all states and the federal government before 10 years from now, for example. So I think that's kind of my my answer to that question when I get it often, is that we don't have precedent on this yet, but for me, I think it's only a matter of time.
Thank you, Eli. If adding an invention to IdeaBlock is not a public disclosure and therefore the invention does not exist in the public domain, then how can it invalidate new patent filing? And is the IdeaBlock a publication, i.e. first to publish?
Yeah, so the first part of that question, it's kind of a two-part thing, is if it's something if it's a private idea, right, on IdeaBlock has the option. It gives the user full control about how they would like to make their idea public or keep it private, right? Because that's a pretty important decision, right? If you make it public, yeah, you're going to get the defensive patent protection, but you're also making it public, right? So for some folks, as a business decision, there's a tendency for some companies as a strategy to keep stuff as quiet as possible, right? And I don't necessarily agree with that strategy, but it's one that a lot of people hold and implement. So the first part of your question essentially was asking, how does if I keep a private idea as a user, if I keep it private and don't make it public, right, how am I going to invalidate a patent? Well, you're not going to be able to invalidate a patent based on a private idea inside of IdeaBlock. The way that you do that is making it public. So you would upload it as a public idea inside of IdeaBlock, or keep it as private for a while and then switch it over to public. We also have that functionality. That's the way that you would be able to invalidate a patent from a third party. You can't keep something secret, and you're right. I think that the kind of implied inside of your question was the implication or the background is correct in its fact that it needs to be public, right? But when you keep a private idea on IdeaBlock, that's a decision by the user to use it for example, trade secret defense or copyright proof that you had something down on paper, or in this case on silicon, right, that you were the creator of that code or music or movie, right? And you can prove you're the first one to do that, right? the public aspects of trade secrets, obviously, you can't make it public or else you blow it up. Copyrights, it doesn't matter if it's public, as long as you can prove that you were the one who actually made this copyrightable material. And patents, patent defense is kind of the public side, right? So my answer to you is you can't. Your question is it's almost there. It's just the background of it is you would make it public inside of IdeaBlock to get the patent defense benefit, right? So you're right. You can't put something on the private side of IdeaBlock and have it block patents, but you can use the private side to protect yourself against if you're holding it as a trade secret, which is the trade secret slide, right? It's that scenario for copyrights. And the second, I'm not sure I remember. It was.
No worries. Let me scroll back up. Is the IdeaBlock a public publication, i.e. first to public?
Yeah. So public ideas on IdeaBlock are a public application. So what we do is when you upload or select an idea as a public idea, we do all of the embedding into the blockchains and all of that kind of core stuff for protection. But we also, after it's uploaded, we also put it inside of essentially add it to our database of publicly available ideas, which is not behind a paywall and is fully accessible by the public. It's black letter law at this point that anything that's available on the internet, free of not being behind a paywall, accessible by those who are looking for something, is public, right? It's a public publication, just like a book or a magazine would be in the last generation, right? So not only do we do that, we also every day go through each of the public ideas on our platform, right? Essentially compiling a list, right? We ping each of the different web idea specific sites. So every idea that goes up has its own URL for sharing purposes and also for purposes of proving that it was public on a certain day. But every single day we go through, get the code back in a HTTP request, right? Just go ping the website and do some other things that prove that this website was available. We archive it every day, right? For example, using Wayback Machine and some other tools that are available publicly. So we're not the public doesn't have to believe us. The court doesn't have to believe us. They can believe these large reputable services to show that on this day, on the next day, all the way through present time, this was available publicly, right? So we kind of and we embed that into the blockchain as well. So in addition to your idea, that hash, we also every day scoop up all the public proof of publication for all the public ideas on our platform and put that in the blockchain as well. So it's provable on kind of two levels.
Awesome. Thank you, Eli. Next question. Worst case scenario, if I use IdeaBlock and it goes under, how do I go back and prove IP?
Right. So that's a good question as well. So, if the platform, if IdeaBlock, God forbid, tsunami comes and takes us away, and every computer that's got anything, even though they're spread out throughout the world, if that data becomes inaccessible through our platform in any way, you're completely fine because the blockchain isn't going away, right? So the hash, you've got the files, right? You got your files that describe the idea, and you've got those you can store those locally as a user outside of our platform. We do it for you. I mean, we store those for you, but you have them too. If you have those files, right, and you have the blockchains, right, which are not, if we go under, they're going to be around forever, right? So you're still able to generate these hashes that are in the blockchain, and you're able to prove it. So outside of IdeaBlock, it's a simple proof, right? So you could do it outside of IdeaBlock as well. So nothing inside of IdeaBlock is critical to that proof. We could go away and an eon from now, you could still prove it.
Great, thank you. The next question, I understand the power of your publishing platform to protect from others patenting inventions that have been discovered before. Does this give any legal protection to prevent commercial use of an idea absent any patents?
Right. So, that question's, I mean, that's a pretty savvy question as well. It does not, in and of itself, give you the offensive right to bring suit, like an infringement suit, to push someone else out of the marketplace, right? So we're not the U.S. government, and we can't, we're not able to issue that kind of right. That's what a patent is. It's essentially the right to exclude others from the marketplace for a temporary amount of time. We can't do that. We're just a company here in Raleigh. The U.S. government is the one who can give that right away. So you aren't able, simply by choosing only to use IdeaBlock for all your IP, you aren't able to now go and patrol the marketplace and start kicking people out, right? But the business reality is, when a competitor is going to bring something to market, right? And even if you're going to bring something to market, eventually I think most folks that use IdeaBlock will, on their important products or products that they were going to bring to market anyway, eventually we'll get a patent on that thing if they're going to bring it. And the same thing is true of competitors, right? So a competitor is, likely going to go try to obtain a patent on that product. Assuming that neither of you do, right? It's open season in the marketplace, and you're just going to have to win, right? So if there's nothing to invalidate, if nobody gets a patent, nobody can kick anyone out of the marketplace. It's kind of a push, right? But what we're doing is, at time X, right, at time zero, you don't know what your competitor is going to be doing, right? So we're really, in that sense, looking at kind of a marketplace that you're involved in. You're a market player and trying to gain market share. Your bet is that your competitors are going to try to obtain patent protection on something, and to prevent them from being able to, in the future, use that against you or use it against anyone else. We're shrinking that window of potential liability for you, right? And that potential exposure today, right? And for much cheaper. So even if they don't get a patent, right? If the reality 10 years later is that you're both in this marketplace and nobody has a patent, yeah, you can both play in it, but you would have limited your potential liability in the event that third party decided to try to get a patent on it and use it against you, right? So we can't, by virtue of simply just the IdeaBlock upload, kick people out of the marketplace, right? You're still going to have to go get a patent on this. And let me be clear, under US law, if you put something on IdeaBlock, even as a public patent, a public idea, you still have a year to file for patent protection, right? So that gives you a grace period to see, okay, how are we going to develop this product? Is this something that we want to go get patent protection over? If yes, great, go file it. You've got that backup defensive protection in case, in that decision-making process, your competitor has gone and tried to file a patent application before you, right? So it gives you that peace of mind over that year as well.
Thank you, Eli. The next question is, can you choose which blockchain is used to hash?
You can choose, we use SHA-256, as I said, just because it's quick, it's easily computable, even on large files, and it's secure, right? In terms of, there are kind of two questions there. I think that what he said, what blockchain you use to hash? I guess a blockchain is used to store the hashes. Hash algorithms, there are different kinds, are used to make the actual hash, right? And for both of those, at least in the beta version right now, the default is the only thing you can use. So we use SHA-256 to actually hash the files and create that alphanumeric hash that's going into the blockchains. And it will automatically go into Bitcoin and Litecoin. It'll go to both of them, right? Eventually we see adding several more as potential options, and price might go up and down on those because prices vary on these different, how much it costs to put stuff into these blockchains as well. But for now, default, really the only option in the beta is to just use those two. But yes, I mean, keying in on that, that's one option that we've kind of highlighted for development in later versions. So.
Great, thank you, Eli. We'll do a couple more questions. The next one is, do you see IdeaBlock as competing against traditional IP law?
Yeah, so I don't see it as necessarily a direct competitor. I think that it's something that fills in kind of the holes in the Swiss cheese, right, of the existing systems, right? So I think it's something that really would strengthen people who have traditionally relied on the traditional intellectual property systems to protect their inventions, and really shore up the points in that process that leave companies exposed. Right? For example, right away when you have an idea, on Monday, and then 3 months later is when the thing is filed. In a first to file system, that's in an industry that might have a really quick turnaround on inventions. 3 months might be too long, right? And if you use IdeaBlock at time zero, anyone that beats you to the patent office is going to be out of luck, right? If you're trying to protect a patent disclosure. So we fill up that hole, and we also give you kind of that runway for a year. And again, in the patent context or in the trade secret context, it gives you protection going as far forward as you want, versus third parties who might try to get a patent on that and sue you. So what we do is we kind of take an imperfect system that exists today, and we're improving it if you use it together, right? IdeaBlock plays nice with the traditional IP systems. Saying that, we do see users, and we foresee that users will use it wholesale as an alternative, right? But I think the better scenario and kind of the more savvy use case is using it as in tow, right? Pair it up with the existing kind of strategies that the companies use to protect their intellectual property today, and going back 50, 100 years, is that we're, instead of having to choose between, okay, we can protect this asset that we don't know if it's going to have market value yet, but we invented it today, right? They've had to go through this process for years of which ones do we pick? Which ones are we going to protect with a patent or with a copyright or a trademark or trade secret? Which one? Now you don't have to choose, right? As soon as it's invented, as soon as it's created by an R&D department, we can today zip it up into IdeaBlock and have that baseline defensive protection, and then we start asking those questions. Which of these bevy of ideas that we thought of last week? Which one of these ideas that are all already defensively protected, right? Which one of these are we going to pick and choose and select for further protection? And you can draw that. You can make that decision a longer decision. You don't have a gun to your head, so to speak, picking those because you're worried about a third party beating you to the USPTO. You can now make a more informed and more heady decision about which of those ideas you're going to pick for further protection. So I think that allows a lot powerful process inside of companies in determining their IP strategy, and also frankly brings the price down, right? Companies that want to protect a wide variety of different technologies, when they're not sure which one will be implemented in the marketplace, they're going to want to protect as many inventions through, in the patent context. You're going to be throwing $60,000 at every single one, as many as you can. Well, now maybe they don't have to do that. Now we can wait a little longer, see how the market reacts, see what customers say, and we can make a much more smarter decision about which ones of these we're going to go and file patent applications on. And I think that it makes for a more streamlined, a smarter, and definitely a more a lighter system for companies, saving them money on that liability sheet.
Thank you, Eli. Next question, what happens if I lose the hash value?
Yeah, so if you lose the hash value, okay, we have, mechanisms that hash value is in Bitcoin and Litecoin forever. Okay, so so it's in there. I mean, it's a big blockchain, but it's in there, right? So, I mean, it's a good question. It would be, you'd be in a scenario then where if you had the files that made the hash, right, you'd easily be able to generate the hash, okay? Because the algorithm that we use, the SHA-256 algorithm, is public. I mean, I could go on the internet right now and upload the files that I just put on IdeaBlock and get the hash out on multiple sites that do it right there in the browser for you, for example. So this is not something that's proprietary to us. This is something that can be used independently. So, if a user, for whatever reason, whether they don't want to, they decide not to be a user anymore, they can take they can take their ideas and go home, right? If they go home, they can take their ideas, go home, and have them verifiable, and they can generate the hashes on those. If they're not able to, if they take their ideas off of IdeaBlock and they don't save the files, their idea files, like the actual substance of their ideas, that's when there's an issue, because then there's nothing to generate the hash out of, right? So, if they have those original ideas that they're trying to protect, which assuming that they delete everything from IdeaBlock that they have on there and walk away, it's safe to assume that if they still see value in those ideas, that they're going to have those files that they can generate the hash from. And then it's just a matter of putting that generated hash into a block explorer again, which is a ton of them available just right now on Google, and you can find them on the blockchain that way, independently of IdeaBlock.
Thank you, Eli. Next question: what is the revenue model for IdeaBlock, and more specifically, who pays the blockchain fees?
Right. So the revenue model is a SaaS model. So it's a lot actually like a subscription model, a seat model that's tiered, right? So we have two kind of sets of accounts where individuals use this a lot too, especially folks musicians, for example, use this. A lot of them use this for their music, right? And so we have kind of an individual tier or individual set of tiers. So 3 tiers there. We have a free tier for individuals, a medium-sized tier, which is like a premium, and then a pro tier for individuals who want to put a lot of stuff on there. And then for companies, we have the startup tier, the growth tier, and then enterprise tier, right? So for each of those, there are different price points, and it's a seat model. So however many seats you see the company needing, right? So however many engineers are making stuff at the company, I mean, that's going to be the price you're going to pay, just a license fee for them on a monthly, or they choose a yearly basis. And it's not unlike just a Dropbox type model, right? In that regard. And then the second part of the question.
Apologies. The last part of the question was more specifically who pays for the blockchain fee.
Oh, right. So the way it works is, I built an algorithm inside of our code, the same code that puts the hashes into the blockchains, that optimizes essentially the fees, right? The transaction fees for each of those to ensure that your idea hash will be validated or confirmed on the next block inside of the blockchain. So you don't have to wait for 6 blocks down the line for your idea to be validated, right? It'll happen in the next, for Bitcoin, 10 minutes, for Litecoin around 5 minutes, right? So we've developed, and I've tested this over the last year to really refine this to pay essentially the lowest fee for that, to ensure that happens over the next 10 or 5 minutes. And it's pretty, we've got it pretty reined in pretty well, where we're seeing those transactions validated correctly. And in terms of who pays for it, we pay for it out of our accounts, our Bitcoin and Litecoin accounts. But if it's kind of a calculus that was put into our pricing model, essentially, where you don't have to worry about that as a user at all, unless we see, and this is also in our terms and conditions, if we see exponential spike in pricing for a Bitcoin or a Litecoin, we reserve the right to kind of pass that on to the user at that point, for future ideas, obviously not going back in time, right? So at the time that if the price went up to $2 million for a Bitcoin, the transaction fees are going to be much larger at that point. So it would be essentially us giving money away inside of our algorithm, and wanting to stay in business, we reserved kind of the right to that. So where companies could, or individuals or users could say, hey, at that point it might be too expensive for them. But we also have ways to kind of get around that through Merkle trees and other ways that we could pack more information into each transaction for each hash.
Thank you, Eli. We'll do one more question. How would a public idea in IdeaBlock be different than just putting the idea on GitHub and making it public?
Right. So the difference between that, and this is, that's a great question as well. So, why wouldn't someone just put something on Medium or any other publicly available site? Well, the difference between the two is the nature of the blockchain. So blockchains are, and the ones that we use are public and permissionless, right? And they are, which means that anyone can use them essentially. You don't have to have permission to use them, and they're public, so they can be audited by anyone. Okay, so for us, in the legal context and evidentiary context, you don't have to drag an expert from GitHub to say, yes, this was actually public on this day, right? If you put something publicly on GitHub, it's still a private company, right? That is hosting this, right? That hosts the page. GitHub's hosted in, it's a Microsoft company now as of I think last year. It's a third-party company, right? That's putting stuff on the internet for you, and to prove that it was actually up and what days it was up and whether it was public, what your the status of the repo was, or if you use GitHub pages or whatever you're using to publish this, what is the status there on that date? And this is information that you're not asking a public blockchain that's auditable by anyone, right? You're asking someone at Microsoft or GitHub to come into the courtroom. You're gonna have to ask him to come to the courtroom and provide proof that this was public, right? There are different ways to leverage tools to try to help that, but at the same time, it's not nicely packaged inside of this extremely provable, immutable, verifiable data set, right? Which in our case is Bitcoin and Litecoin. So the difference there is really the provability and the evidentiary power of the difference between those two.
Awesome. Thank you so much, Eli, for your time today and the wonderful presentation, answering all the detailed questions. I encourage
Great questions. I will say it's a very savvy group.
Awesome. I will encourage anyone, if you need help reaching out to Eli, again, please, you can reach out to me or directly. Eli has put his information here, so please don't hesitate to reach out. And this recording will be available on Riot's YouTube channel. Thanks so much, everybody.
Thanks so much, everyone.